5 prior felonies, 31 misdemeanors. At some point, the court stops seeing mistakes and starts seeing a pattern that just won't break.
But when you're 55 with 5 prior felonies, 31 prior misdemeanors, I think you kind of understand what you have to do.
Right, we point out well enough he shouldn't have fires. And he didn't have 1 firearm, he had 6, 4 handguns, shotgun, and a rifle with ammunition. And he knows he's not supposed to possess that. Department of Corrections did their compliance check, found that he was not in compliance. And to top things off, Your Honor, he's on probation at the time. And besides that one, there were the controlled buys that were done. He pled to 1 of them. There was 2 of them in total. And, he's also on probation. I heard the explanation, but, he's on probation. He knows better than that. And yet he still commits these crimes. Your Honor, we're asking you adopt the recommendations that set forth that he be sentenced on the felon in possession by a prohibited person to the 24 months mandatory, the felony firearm mandatory with 7 days credit for that one. And then for the other count, the recommended 24 months, and that is going to run consecutive to that with no credit.
The second 2 files are new sentencings. The defendant is present, represented by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Burkowski. For purposes of the 21 file, the defendant, and actually in all files that is, on January 26, 2026, Mr. Galbraith pled to probation violation. In 7377, he pled to possession of a weapon by a prohibited person ×2, as well as felony firearms and possession of a controlled substance. In the final file, 7378, the defendant pled to delivery of a controlled substance. Ms. Karen Everland has prepared the pre-sentence report for the new files. Ms. Mandy Alexander prepared the...
His prescription had been reduced by his doctor, and he was having pain. I believe was that his son, who was having some mental health problems, was going to be living with his mother. They were worried about that son using guns perhaps for suicide or something. So, looking back, he should have made other arrangements for those guns other than taking them to his house, but he was doing what he thought was the lesser of 2 evils at the time. And then as far as the controlled substance deliveries, according to my client, that the CI was a friend of his who he had known for some time in the construction world, and this friend had told Scott that his prescription had been reduced by his doctor and he was having pain. Like even Scott, carpet laying and flooring is really bad on your body.
Primarily your knees and your back.
So he thought he was helping this friend by giving him or selling to him his deceased relatives' leftover supply. Again, that was a bad decision. He's not a doctor, he's not a pharmacist, but at the time he thought he was helping this friend who turned out to be a confidential informant. As far as the recommendations, my client is beside himself today, having to go back to prison. He's asking that you not impose the 2-year mandatory minimum, or if you do, that the other charges will run concurrent with that. It's this practitioner's opinion that that is not even feasible. The law says mandatory minimum, so I don't think you can do that, but he asked me to ask you to do that anyway. He does acknowledge that he made some mistakes that are crimes and that he has to be held accountable for his actions. And if you recall, he did plead guilty to virtually everything that was charged against him. That's what we're asking.
Also, is there any objection to one pre-sentence report covering the 2 newest files?
No, Your Honor.
Okay. Did your client wish to address the court? Mr. Galbraith, go ahead, sir.
I'm by addiction. Trying to help my kids. I'm a father. I'm a husband. Fire. I did do the right things. Trying to protect my family. Wounds and stuff, I wasn't gonna keep them. All this stems down from a probation violation. I got drivers. 120. Scared of the future. I'm sorry, I'm trying to fight addiction. Doing this I can.
Anything else, sir?
I have failure tests when all that.
Thank you. This was Nighthawk, was it not?
Yes, it was.
I can't stress enough, it's a new day in Huron County. It has been for a couple of years now with the Nighthawk program. This is a Department of Corrections program. When individuals are placed on probation, it's been, at least from my experience in the past, across the state, frankly, when I practiced across the state, that people placed on probation are placed on probation, they report to the probation agent, and they're not looked upon in a surprise situation. In other words, when you schedule your meeting with the probation agent, you meet with the agent, you report to the agent, that's all. And you're done. The Nighthawk program is a completely different program. Department of Corrections individuals will come to your house when you least expect it, and when they show up, they have the right to search the home.
This is where the Nighthawk program changes everything. Unlike standard probation, surprise compliance checks mean there's no hiding violations. And when officers show up unannounced and find firearms in felons' home, that's a direct, undeniable violation, no gray area.
Home, premises, computer, everything, vehicles, to make sure individuals are compliant. And we've had a number of cases come before this court, including this one, where an individual is merely on probation for operating while intoxicated in their defense, and they're in possession of firearms or ammunition. And the court every time will tell the individual who's on probation, to be placed on probation, you are not to possess a firearm. Period. On top of that, individuals who have prior felonies know that as well. Once you're a felon, unless your rights have been restored, you do not get the right to possess a firearm. And that's what happened here. Not one, but Mr. Rakowski, 6.
Yes, sir.
6 firearms. And the explanation is, well, I'm concerned about my son. And the court appreciates that. I'm not discounting that, Mr. Galbraith, at all. But they can't be in your possession, in your home. There are other avenues. Easy for the court to say no. I mean, we're armchair quarterbacking this, Monday morning quarterbacking this, essentially. But there's a proper way to do it. Sadly, you didn't do that. On top of that, you fell upon maybe the weakness of another individual in controlled buys, and you delivered a controlled substance. I'm not considering the other alleged incident. I'm only considering the one you pled to. That's all the court can consider. But when you're 55 with 5 prior felonies, 31 prior misdemeanors, I think you kind of understand what you have to do. And sadly, you didn't. And you have to be held accountable for that. So it will be the sentence of this court. And this is under statute. This is mandatory. This is file 7377. I'll begin with count 4. The defendant is committed to the Michigan Corrections Commission and placed in their custody for a period of 2 years, flat. Credit for 7 days previously served. $68 in state costs will be ordered. In count 1, count 2, and count 3, it will be the sentence of the court that the defendant be committed to the Michigan Corrections Commission, placed in the commission's custody for a period of not less than 2 years to 10 years. Actually, that's counts 1 and 2. 2 years to 10 years. No credit for time served. And in count 1, all firearms and ammunition seized by police will be forfeited to the investigative agency for disposition. That would be counts 1 and 2. Count 3, committed to the Michigan Corrections Commission for a period of 24 months to a maximum of 8 years. Again, credit for 0 days served, $68 in state cost in that count as well. Counts 1, 2, and 3 will be served consecutively to count 4. And that's by law. In 7378, it will be the sentence of this court.
And there it is, layered consecutive sentencing. Not just one punishment, but multiple stacked on top of each other. That's how the system responds when violations pile up over time. So here's the question, was this outcome sealed long before today?
That the defendant be committed to the Michigan Corrections Commission, placed in their custody for a period of not less than 24 months to a maximum of 40 years. Credit for 7 days previously served. 7378 shall run consecutive to count 4 in 7377, but concurrent to 7377 counts 1, 2, and 3. It will be the sentence of this court for a period of not less than 18 months to 7.5 years. Credit for 218 days. He's unsuccessfully discharged from probation. All monetary obligations remain collectible. This sentence shall be served concurrently with all the other files except for count 4, which is the felony firearms count. It must be served consecutively. Again, May 18, 2026 would be the due date. Anything that was missed, Ms. Everett? All right. It's my duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, court will assign counsel